You telling me to she?
She has her children.
No, I'm sorry.
Were you telling me to be quiet?
No, sir.
No? Oh, okay. I was just gonna be quiet if that's what you were telling me to do.
Welcome back to another intense courtroom session, where bond decisions, gang shooting allegations, and plea deals collide. Judges must balance fairness with public safety, while defendants fight to stay out of jail. Stay tuned, because several rulings today could instantly change lives. Subscribe, like, and share for more gripping courtroom breakdowns.
All right. Record should reflect we had a bench conference in this case. Really, there's a motion by the people to modify his bond.
And that's correct, Your Honor. It's our understanding that this case was picked up while the defendant was on bond for another case involving controlled substance delivery and manufacturing, as well as probation in circuit court. And I believe per the statute, he should have been given an surety bond. So this time I would be re-requesting our original request of $50,000 cash. However, I understand the court. Thank you.
And Your Honor, we do understand the people's concern as well as what the statute states. However, my client has been out on bond on this case with absolutely no issues. We know that there is another case. He was present for his preliminary examination on Tuesday for that matter. I believe that the issue of bond was addressed at that time, and the judge put him on a home confinement tether GPS. That was Tuesday. He does have that tether on, to my understanding. Yes, there may be a violation. It has yet to come up in circuit court as of now. However, he's been doing everything he's supposed to do on bond, Your Honor. So I'm asking that the court, if there is a requirement to put some type of cash component, make it as minimal as possible to allow my client to continue complying as he's been doing.
Right. I would find that the setting of a personal recognizance bond under the circumstances was use of discretion by the magistrate. Set his bond. I am going to take into account the fact that, yes, it should be some type of surety bond, but I'm taking into account that, as defense has indicated, he's been doing what he's supposed to be doing, other than picking up this case while he was on bond on the other thing. But since that point, he's been cooperative. He's been doing everything. So I'm not going to require what the people had requested, and not necessarily a surety bond, but I'd be looking at it this way. I'm going to set his bond at a 10% bond in this matter, at least that way he can post it. I will also set the, you want this set for preliminary?
Yes, Your Honor, please.
And your discovery is complete?
To our knowledge, Judge.
All right, discovery being complete. Would the people have their witnesses available to 17?
Double check on the. We are just waiting on the final call.
Pardon?
I requested the 911 call, but I have not received it yet.
Okay. So
We're fine proceeding.
You're willing to proceed?
That's right,
with
Your
the
Honor.
911 call. All right. Preliminary examination in person, March 17, 2026. 9 a.m. before Judge Moore. All right. I'll set his bond. Defendant is remanded.
Thank you, Judge.
Thank you. Does call the case People versus Larry Carsora.
Judge. Alex Jablowski, the people here. Worship, Mr. Assistant Public Defender, on behalf of Mr. Larry Kosaru.
Mr.
Kosaru, please ask the jail to unmute you and then state your name for the record. Judge.
You may.
Hello,
Hello, state your name, sir.
Larry Kazaru Jr.
Close. Thank you, Judge. Notes in my file indicate that we did just receive some additional media discoveries from Mr. Kazaru. I'd be asking for an adjournment to review that with him.
All right, you want the 19th or 26th?
The 19th is fine, Judge.
Probable cause conference, March 19th, 2026, 9 a.m. Bond continues.
Thank you, Judge.
Thank you. Thank you, sir.
Thank you.
Court calls case People versus Thurman Pool.
Raymond Cook for the people.
That is correct.
Good morning, Kareem Johnson, on behalf of Mr. Poole. This is the co-defendant case, Your Honor.
Yes. And
He's gonna be.
the next in. Your name, sir? Thurman Pool. All right. What are we doing on this?
Your Honor, we're setting this for exam, and I would like to address my client's bond.
On the, who has the co-defendant?
Mr. Burgess, that's.
Is that going to be the same position on?
Setting it for exam here?
Yes.
That's correct.
All right. And Mr. Johnson, you're not available the 17th.
That's correct, Your Honor.
All right. So I think I said his other matter for the 31st when we looked at dates. Will that work for you, Mr. Burgess?
That's fine.
Is that okay? So who's what are the numbers?
I updated your ship for the 31st. You've got to.
Well, we'll just start loading her up at some point. I'll set preliminary examination in person March 31st, 2026, 9 a.m. before Judge Washington. All right, as to bond.
Your Honor, my client does have significant family support. His mother, his brother have been in constant contact with me. He does have a place to go and responsible people to make sure he will abide by any bond conditions. We concede that allegations made in this case are serious. However, I don't believe, other than a picture taken over an hour after the incident, there's no electronic, scientific, or personal identification that places my client at the scene of this crime conducting any crimes, Your Honor. So because of that, we'd ask for a significant bond reduction to $15,000 cash, surety of 10%.
Current people object to any change of bond at this time. The basic allegations here is that the defendant, along with the co-defendant, fired at an occupied house. My understanding is that that house had previously been occupied or owned by members of a rival gang, and that this was a gang-related shooting. The members or the individuals in that house were not really with that gang, completely innocent, is my understanding. But the defendant, the co-defendant, fired, I believe it was 25 rounds into or at that building, including some of those rounds being fired by a fully automatic weapon, some of those rounds being fired by a rifle. I have significant concerns for public safety. If the defendant is to be released now, I'd ask that bond remain as set.
I guess the only concern that I had is Mr. Johnson indicated there is evidence that connects this defendant to this crime, I'm presuming.
Yes, it's a lengthy report. I can go through and try and find exactly what evidence that is, but I can have just a second.
Well, that's okay. It's just, it made it sound as though there's no evidence that connects this individual, but that's not what the people's position is.
Correct.
At this point, given that exam would be pending, I'm going to deny the request for a change in bond. Bond will continue. All right.
Yes, sir, Your Honor.
Thank you. Thank you. Court calls case People versus Willie Collins.
Morning, Your Honor. Raymond Cook for the people.
Hearing on behalf of Mr. Collins, Your Honor. Did you get my green sheet?
I did.
So we're requesting an adjournment.
That's to go. Okay. I have a violation, however.
Yes, I shared it with him.
How come he hasn't gone?
Your Honor, there was some miscommunication when he was released. And he has a plan now. He lives on Berkshire. He has a plan so that he can, and he'd be clean today if we were to test.
But he hasn't been over to test.
Well, he knows where it is now.
But he didn't know before?
No. He just said he didn't know where it was, Your Honor.
Well, why didn't he find out?
Well, be careful what you say.
I mean, he hasn't tested at all.
Well, he'd be clean right now,
Well,
today.
but he hasn't tested at all while he's been on release.
That was from what, the 24th, so it's not like it's a couple months.
Here, the judge focuses on a critical issue: compliance. The defendant was ordered to report for drug testing but never showed up, blaming confusion about where to go. That explanation clearly frustrates the court. When supervision rules are ignored, judges often react quickly. Do you think this excuse sounds believable?
So he just didn't go.
Well, he didn't know. That's my information,
He didn't know what.
that he was supposed to go. Well, be careful what you say.
Your Honor, when I was talked to by the magistrate, I just got Jackson County doing a year. I'm on probation in Jackson County. So the magistrate told me that I can test when I go report. I just reported Monday
He told you what?
that I had to reply with Jackson County's probation.
Comply with Jackson County probation. He means, I think he has tests as a condition of his probation in Jackson County. So Jackson County,
I don't have any record of that. None it's written over.
that's what he's representing, his information and belief when he was arraigned, that he could substitute the testing in Jackson here. That's all. And there was a little miscommunication on his part. So
But he hasn't. Have you tested in Jackson?
Yes, sir. I just
When?
Monday,
When?
sir.
he'll sign a release right now if you want.
Well, he needs to get over there and do all of that, but I'm not gonna have a circumstance where we tell him to test and he hasn't even gone over there and reported.
But he's testing at
He
another.
hasn't reported and hasn't been in contact with our community correction.
Well, he's prepared to do it right now. He's just being double dipped, testing two places, that's all. And it's not your fault.
Oh, I know it's not my fault.
It's not your fault. Quit laughing.
March 26, 2000, I'll set his adjourned probable cause to March 12, 2026 at 9 a.m. But at this point, defendant's bond is revoked, defendant remanded.
Now he's gonna get in trouble in Jackson.
I didn't do it. I just did my job. Calls the case, People versus Marcus Claiborne.
Morning, Raymond Cook and people.
Morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Marcus Claiborne.
Your name, sir?
Marcus Claiborne.
Discovery is complete.
That's correct, Your Honor. I believe the court just set the exam on the co-defendant.
Yes. So I will set preliminary examination in this matter in person, March 31st, 2026, 9 a.m. before Judge Washington.
Judge, could I briefly address bond?
You may.
Thank you, Your Honor. Bond's currently set at 100,000 cash surety. I know the court just heard the allegations in this case. I'm assuming Mr. Cook meant that they were allegations, by the way, when he stated it on the record before. But either way, Judge, my client has no prior record. He's 18 years old. Even understanding the serious nature of the charges, that the court would consider at least a 10% provision on the current bond, so that my client can obviously appear voluntarily and obviously mount a defense on his own behalf. I'm asking the court to consider that. He does have family in the court. I've been in touch with family members. He has very close ties to the community. He's not a flight risk. I understand the danger of the community can be addressed, Your Honor, with some bond conditions, including a tether and or house arrest conditions. Thank you, Judge.
Your Honor, for the same reason previously stated, people object to a change of bond at this time. I have significant public safety concerns with this defendant. At least, as I iterated before, what I believe is a gang-related shooting that unfortunately involved innocent individuals who were not affiliated with the gangs in any way. I believe the defendant poses a risk to the community, for at least I asked bond remain the same.
Motion for bond reduction is denied. His bond will continue as set. Thank you. Court calls case People versus Alyssa Anala. Are you Miss Anala? Come on up. I probably got your first name all wrong. So, what's your name?
Alyssa Anala.
Anna.
I did it. I did the same thing, Your Honor.
Did you?
So,
Okay.
Yeah. And good morning, Your Honor. May it please the court, David Burgess on behalf of Ms. Anala, standing to my right.
All right. What are we doing?
Your Honor, I was just appointed on this matter this week. I'm just asking for a brief adjournment for discovery purposes.
Probable cause conference will be adjourned to March 26, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. All right. Court calls case People versus Robert Jameson.
Morning, Your Honor, Raymond Cook for the people.
Morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Jameson, who approaches the podium. Please state your name for the record.
Robert John Jameson II.
Your Honor,
Joy Gaines, Senior Assistant Public Defender, representing Mr. Jameson on the controlled substance matter.
All right. What are we doing?
Your Honor, on my matter, we're asking to have it set for an exam.
Your Honor, we made an offer to the prosecutor, and the prosecutor at this time has indicated that he wishes for the cases to track each other, so we will set ours for a preliminary exam as well.
Discovery complete in both matters.
As far as I know on my case, yes, Your Honor, I've gotten everything from the people.
As far as I know as well.
People have their witnesses available the 17th.
Your best, Your Honor.
Preliminary examination in person will be set March 17th, 2026, 9 a.m. before Judge Barr in both matters. Bond will continue.
Thank you, Your Honor.
Thank you.
Court does call the case People versus Delisa Robbins.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Ms. Robinson, who should be on Zoom.
Oh, there she is. Ma'am, state your name.
Lisa Robinson.
I have before me a plea form that indicates she's going to be pleading guilty to an added count for larceny 200 to 1,000 to 1 year offense. Upon her successful plea, counts 1 through 3 will be dismissed. Defendant agrees to pay $100 restitution, and the sentencing judge will check. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes, Your Honor.
Ma'am, if you could please raise your right hand. Oh, there she is. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
All right. Are you telling me to she?
She has her children.
No, I'm sorry.
Were you telling me to be quiet?
No, sir.
No? Oh, okay. I was just gonna be quiet if that's what you were telling me to do. Can you state your name,
Sorry
please?
about that.
No, it's
Delisa
okay.
Robinson.
All right. Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of larceny 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 or $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. Do you understand that, ma'am?
Yes.
And understanding that, do you still wish, I should also advise you that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form or had it signed on your behalf. Is that correct?
That's correct.
Any question regarding any of those rights?
No, sir.
You understand that you're waiving all of those rights contained on that form, including your rights, your trial rights under paragraph 5.
Yes, sir.
You understand your way, you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Yes, sir.
Yes, Your Honor.
All right. And were you on which one? Is it
I'm on
probation?
probation.
All right. Were you on probation at the time of this offense?
No, sir.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will,
Yes.
and also because you believe that you are indeed guilty of this offense?
Yes.
December 6, 2024, at the location of 606 East Hoover, City of Ann Arbor, Washtenaw County, State of Michigan. What did you do that makes you think that you're guilty?
I used someone's credit card.
All right. So you used somebody's credit card without their permission?
Correct.
And so you had it in your possession. They didn't know you had it?
Yes.
This moment shifts from arguments to accountability. The defendant openly admits she used someone else's credit card without permission and received goods worth more than $200. That admission seals the guilty plea to misdemeanor larceny. Now the case moves towards sentencing, where the judge will decide consequences.
Okay. And when you used it, did you receive any goods or services?
Yes.
The amount of goods or services that you received, was that in excess of $200?
Yes.
Yes? All right.
Yes.
All right, ma'am, I do have to advise you that if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
None from defense, Your Honor, and she's already talked to Oakland probation.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 4, counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
March 27th, 8:30 a.m.
March 27th, 2026, 8:30 before Judge Perry. Bond will continue. Thank you.
Thank you,
Thank
Your
you,
Honor.
ma'am. Case People versus Tenaris Williams.
Carolyn Foster Tucker on behalf of Mr. Williams, who is approaching.
Your name, sir?
Bernard Williams.
Thank you.
Your Honor, we're requesting an adjournment. Mr. Bernstein was just recently appointed.
Probable cause conference will be adjourned March 19th, 2026, 9 a.m. Defendant's bond will continue at this time. Thank you.
Thank you.
Courthouse case People versus Vanessa Crosby.
Al Chadwick for the people.
Veronica Glenn on behalf of Ms. Crosby.
Ma'am, could you state your name?
Nisha Crosby.
Your Honor, we would like to request an adjournment.
That objection, probable cause conference will be adjourned March 26, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Can it be a different court date? Because I got another court date, March 26th.
Say again?
I have another court date before I enter the court, March 26th.
So you have another court date on the 26th?
Yes, to friends of the court.
Friend of the court.
Yes.
Turn this out to April 2nd. Will that work for you?
Yes.
April 2nd, 2026, 9 a.m.
Okay, thank you.
On continued. Thank you. Court calls case People versus Ashana Barrett.
Alexander, on behalf of Your Honor.
Michael Gaddy, public defender on behalf of Ms. Barrett. Honor is approaching.
Your name?
Ashana Barrett.
All right.
Your Honor, we'd ask the court to set a preliminary examination of this matter.
You have all this covered.
Yes, Your Honor.
People have their witnesses available the 17th.
We'll do our best, Your Honor.
Preliminary examination in person, March 17th, 2026, 9 a.m. before
Judge Moore.
Judge Moore.
If I could be heard on bond, Your Honor.
You may.
Your Honor, Ms. Barrett is here, she comes here from the jail as the court recalls. She was remanded last week for a violation of her bond. I believe she admitted that violation. She was and remains trite about it. She understands now that I think it's been made clear to her that the court's rulings are things that need to be obeyed, and she needs to be extra conscientious about doing. She does not reside with the complaining witness in this matter, and if the court deemed fit to release her, Heather could ensure that her whereabouts are known at all times so that there would be no contact with the complaining witness.
Any response from the people?
Your Honor, I was leaving the discretion of the court. However, I would have concerns and would ask for a home confinement. The bond violation occurred while they were driving around. Or actually, I don't know if the would ensure that they're not in the same location. So I would ask for a home confinement. That would be no issue with that, and that it's not a police step that it resides.
Lady, is that correct that you understand that you've got to abide by the court's order?
Yes, sir.
I will amend her bond. I will reinstate the previous bond amount, but with the conditions will be reinstated. All the bond and conditions will be reinstated, but she must be fitted with a home confinement GPS tether prior to release.
Okay.
Thank you, Your Honor. You gotta stay home.
Court calls the case People versus Zakara Daphne Barciaga.
Assistant Public Defender Chelsea Virgil is with and on behalf of Jakara Daphne Bursiaga. Jakara Daphne Bursiaga.
Got it. Okay. I have before me a plea form that indicates that she is going to plead guilty to the charge of an improper use of a firearm in a motor vehicle, improper possession in a motor vehicle, the 90-day offense. And upon her successful plea to that charge, count one would be dismissed. She's agreeing to forfeit the device, which I guess is a taser. Well, and there's a sentence agreement to HIDA. Does this statute section include a taser?
The charge which she's pleading to,
Yes.
I don't think it does. I didn't check what the charge that indicate the charge she was, the original charge was.
Right. Well, but she didn't have a firearm, correct?
That is correct, Your Honor. And to further complicate things, I apologize. I just realized the plea agreement says guilty. This would be a no contest plea. I believe I submitted the police report. I apologize.
And I don't have a police report, but I don't. Did the police report come? Maybe, hold on. No, I don't have a police report. I don't recall reading.
I'm sorry. I was thinking of a different case. It is a guilty plea. I'm sorry. I talked to her about that. I'm sorry, Your Honor.
Okay, I'm absolutely confused. And you know what? Mr. Shields never confuses me. And she's usually straightforward right on it.
Please
You
disregard
just
my
sent me in another
statement.
direction. That's okay. I'm still okay. So now I can go back to what my concern was. And that is, I'm a little bit concerned about trying to take a plea regarding a firearm when she's not in possession of a firearm.
Can we approach?
She said no. Bless you. Come on.
Thank you.
After a packed docket filled with bond battles, adjournments, and one clear guilty plea, the courtroom closes with a reminder that every decision matters. Some defendants keep their bonds, others face stricter supervision, and one admits guilt outright. Like, comment, and subscribe for more shocking courtroom stories and real legal drama.